name is Rand Wallace. I'm presiding over this session, which is our 10 o'clock session this morning. Joining me on the panel are Judge Dan Traver from Orange County, and we also have the privilege of having Ninth Circuit Court Judge Julie O'Kane, who is filling in as an associate judge. We thank Judge O'Kane for taking time out of her busy schedule to help us out here today. We have on this case, it's Jeremy Ortiz versus the state of Florida. And before we start the oral argument, I would ask if you're not speaking as an attorney that you mute your microphone, and also that you make sure that you have any devices that may create noise turned on silent or off while you're on the call. And I'm going to assume that the appellant would like 5 minutes of rebuttal unless you tell me otherwise. And so with that, it's Stephanie McHenry for the appellant. Ms. McHenry, you may begin.
May it please the court. Stephanie McHenry on behalf of the appellant, Jeremy Baig Ortiz. I would request the standard 5 minutes for rebuttal. This is an appeal of the denial of Mr. Baig Ortiz's motion to suppress. The question in this case is whether the seizure of Mr. Baig became unreasonable because the stop was unlawfully prolonged. In this case, the seizure of Mr. Baig was prolonged by Deputy Jacino in a multitude of ways. I'd like to address first, for the purposes of oral argument, the particular unnecessary checks for warning numbers in preparation for traffic court done by Deputy Jacino in this case.
Ms. McHenry, before you get started with that, can you tell us in your best case scenario for the facts of your case that you want to argue, how long was the stop prolonged in your opinion based upon the facts that were before the trial court?
Yes, Your Honor. So I think in a totality, I think at least probably 6 minutes. The way I calculate it for the purposes of the brief was each separate different method of prolonging the stop. So for example, when the officer makes the call to K9, the stop is prolonged by at least a little over a minute. The unnecessary checks prolongs the stop by 2.5 minutes, at least by Deputy Jacino. On page 218 of the record, the video is played, and we go through the starting time of when the checks into cafe for these event numbers are run to the stop time. I think it's hard to calculate when we're talking about these theoretical redundant checks that are done. For example, repeating the warrant check and running the license multiple times. It's because on the video and during the motion to suppress, we're going through multiple screens. I think it's hard to calculate, particularly how long running those redundant checks occurred. And then I think the stop is unquestionably prolonged at 8 minutes because what we have is the second ticket took 8 minutes to write. So you have at least that 8 minutes of time if the court agrees that the second ticket is invalid, where the stop is prolonged by 8 minutes through the creation of this second citation without probable cause.
And the stop from start to finish, was it 20 minutes?
I believe it was about at least 28 minutes. The way we calculated it at the motion was 20 minutes for the first ticket and then 8 minutes for the second one.
Okay, all right, thank you.
And if we going back to those unnecessary checks, on page 218 of the record, you have Deputy Jacino admitting to running these event numbers in preparation for traffic sort. So while officers can ordinarily run traffic-based inquiries, this power isn't limitless. An officer must be reasonably diligent. And in this case, when Deputy Jacino admits to going into cafe in MyCAD for prior warnings, which is not unrefuted in the state's answer brief, he's clearly running an unrelated check. He admits on the record that these event numbers are not necessary. The testimony and the response by the state that this is part of Deputy Jacino's standard operating procedure, or that this is how he does his traffic check, should have no bearing on the court's decision on the constitutionality of him doing so. Because in this case, the reason why there's a limitation on these powers and the only reason that these checks are allowed is to ensure the vehicles on the road are operated in a safe manner. In this case, when Deputy Jacino is running the check for warning numbers, he's admitting that he's preparing for traffic court. So the court in Rodriguez talks about how it's about what an officer actually does. It's fact specific. There's no dispute about the facts that he goes back and he looks for these prior warning numbers that he doesn't need. And he admits on the record that he's writing the ticket anyway. So while the court may be inclined to say, well, an officer might, during a traffic stop, want to look at what these prior warnings are, in this case, it didn't matter. And Deputy Justino had already started writing the ticket, and he was writing the ticket regardless of what that information was. And so I think it's unquestionable that he's running an unrelated check, which prolongs the stop. The second way.
What deference do we give to the trial court's specific finding that every moment that deputy was in the car, that he was doing something that was related to researching or writing that particular citation?
Yes, Your Honor. So the trial court's factual findings would be given deference to the extent that they're supported by competent and substantial evidence. And so in this case,
your argument, so that I understand it based on what you were just saying, is that the trial court basically abused its discretion in making that particular factual finding as it related to the warnings?
Yes, I think as insofar as the trial court made the blanket statement that every second that the officer was using his computer, that he was doing something related to the traffic stop. I think actually that's more of a legal question, is what, I don't think the trial court found a different set of facts. So what
we can agree it would be different if the computer screen switched to, say, example, the officer's Instagram account. I'm having a little bit trouble disturbing that particular factual finding when it seems to have been at least a bit, if not entirely, incumbent on the trial court's evaluation of the officer's credibility in terms of testifying what he was actually doing and why he was doing it.
I think, Your Honor, that there's not a dispute about what the court found the officer was actually doing. I think maybe there might be a dispute about why he was doing it, but in terms of what was happening, there's no dispute. So I think the question is a legal question, is whether what was happening related to the traffic stop. So I think
so assume for my next question, and I'm sorry to interrupt you, but assume for my next question that we agree with you and we try to write that opinion. Are you asking for an opinion that says that in this scenario, a police officer, as a matter of law, can't search a database for previous traffic-related warnings?
No, Your Honor. I think that because these situations are so fact-specific, that an officer can't do so when he's going to do so for the purpose of preparing for traffic court, because preparing for traffic court is not needed to write the citation. And it's not like Deputy Justino said, I'm looking at this to see if I'm going to write my ticket, which I think most courts, and we can all agree, an officer might do that as part of an ordinary traffic-based inquiry. See, well, let me see if this person was warned before to determine if I'm going to write that ticket. That's simply not what happened in this case. Deputy Justino admits that he was already going to write the ticket and actually stopped writing the first citation to go look for these numbers, which he never used. And so I think that officers cannot prepare for traffic court. I think that's the finding the court makes, that you can't go and find out a person's spend time looking up their entire, however many tickets they have and what the warnings were, and start writing a long summary that you're going to give to the traffic court judge if the person argues that they've never gotten a traffic ticket before. And I don't think that the court has to overturn any factual findings made by the trial court, because I don't think there's any disagreement between any parties as to what those facts are. I think at most the disagreement comes when we start talking about the next way in which I argue the stop was prolonged, which is those duplicative checks. But I actually want to turn to kind of, I think, what makes the stop impossible to not be prolonged, which is the fact that the detaining officer, in this case, Deputy Justino, is the same officer that made the call to K-9. So there's no precedent to my knowledge, or Florida case, or even Supreme Court case, that addresses whether the same officer that is the detaining officer writing the citation is allowed to also make the call to K-9. And I think in this case,
I guess my question is it unreasonable for it to be the same officer that's processing the traffic ticket and the same officer that makes the call to K-9? Did you find any case law about that?
No, Your Honor, I don't think none of these precedent or the law that exists has a situation where it's the same officer. And I think it is unreasonable because the reason that the Supreme Court and this court have allowed dog sniffs in general during stops is because they don't prolong the stop. There's no such thing as a de minimis delay. And because a dog sniff is an unrelated measure aimed at detecting evidence of criminal wrongdoing, that's why I think the court has to find and should still find that because there's no such thing as a de minimis delay, that the same officer simply can't do it. The Fourth District Court of Appeals in Jones makes a point of saying that the stop is permitted as long as it doesn't extend the time, and they specify that it takes the detaining officer to complete the task. So in this case, the same officer did it. Deputy Justino, even though there was another officer on the scene, makes the call, and he does so in a way that takes over a minute for him to take the call. He's not walking back to the car. I think as far as that factual finding is concerned, the court can watch the video, which I think is permitted because the appellate court is in no different position than the trial court to watch kind of those exhibits. And the reason the law is so strict and binding is because the dog sniff is unrelated. We only allow it because it doesn't curb anyone's rights, but when the detaining officer is making the call, it does.
Let me propose a hypothetical to you. A car's pulled over and for a traffic offense. There is an incredibly strong odor of marijuana emanating from the car. The doors are closed. The window is closed. The officer then gets basic information from the driver and proceeds to walk back to his or her car to process that information. Even though the officer is patently aware that there is marijuana in the car, that officer has to wait until another officer arrives on the scene to call for a canine to come to the scene and perform a drug sniff on the car. Is that what you're saying?
No, Your Honor, because I think in the hypothetical posed by Your Honor that there's an independent basis for which to detain the individual, that being the alleged odor of marijuana. So in that case, the officer could make the call with that while having probable cause for the seizure. In this case, there was no odor independent basis to request canine. The officer just did so because he wanted to. I don't think anyone alleges that he had suspicion of wrongdoing anywhere in the record.
Slightly different hypothetical. You've got a situation that is exactly the same as this particular instance, and the deputy tells the person driving the car that they need to wait in the car as opposed to getting out. And he walks back with the goal to start writing the citations and does so. Calls for backup. Another officer shows up, walks up to his window, and the first officer, who had been unceasingly writing the citation, just rolls down his window and says, "Call a canine." And the other officer then does that. Is that an unconstitutional prolongment of the stop? Because the act of rolling down the window and saying, "Call the canine," wasn't geared towards writing the citation.
I don't believe so, Your Honor. I think that's more akin to the situations that Rodriguez talks about where an officer goes to get a jacket or blows his nose or something. That is, I think in this case, it's different because when you conduct a minute by minute analysis, this does take over a minute. So in that case, telling the officer and rolling down the window to call canine, and I think in that hypothetical would take likely 5 seconds to do.
What if there's a back and forth between the officers? Well, why should I call canine? Well, I pulled him over and, this is what I'm thinking. This is what he said. Oh, which canine do you want me to call? In my scenario, can you stretch that out to a minute? Can it become then constitutionally impermissible?
I think it can, yes. I think if that unrelated inquiry, and I think the reason is when you look at, for example, cases like Arizona v. Jones, where they start talking, the officers start having unrelated conversations with no one advancing the stop. I think it comes to that point where once you get to that minute, you started to materially prolong the stop. And this court has said that minute is the mark once we do that.
Is there ever a scenario where in a one officer stop that didn't become a 2-officer stop, that one officer could call a canine without unconstitutionally prolonging the stop?
I think if it occurred the way that the state alleged it occurred, for example, Deputy Justino makes a 5-second radio call while walking back to the car or while waiting for the tickets to print. If he had waited while the tickets were printing and said, can we get a K-9 unit out here? Or if it was actually while he was walking to the car, if he's multitasking or typing or waiting for the NCIC check to come back, then in those cases it would be permissible because he's going to be stuck sitting there waiting for the tickets to print or waiting for the FCIC check to come back. And so if it had happened that way, I think he wouldn't have materially prolonged the stop. The last way I think the stop is kind of clearly prolonged in this case is because you have that second ticket written for something that there is no competent substantial evidence to support the trial court's finding. And I actually think, in fact, in this case, the trial court doesn't make a finding as to whether the license plate is legible, despite my request of the lower court to make a finding. Instead, they found that the officer could have written 30 tickets if he wanted to, and it wouldn't have mattered because he had probable cause for the stop. So I think there's some confusion as to the probable cause for the stop and the probable cause for the continued seizure. In this case, I think there's impossible to say that there's substantial competent evidence that the license plate was illegible from 100 feet when this court looks at the video and looks at the picture. The illumination of the license plate is a separate issue from the legibility of the license plate. And so I think that when the trial court plainly erred, and this court can make that factual finding because it's so plain that the license plate was in fact legible, there was nothing wrong with it. And therefore, because Deputy Justino finished writing a single citation, that Mr. Baig's continued detention was unlawful.
If we accept the 4th DCA's construction of that particular statute, which I think you're urging us to do, is there an independent basis to affirm the trial court's ruling, kind of on a tipsy coachman theory, that this was a reasonable mistake of law on behalf of the officer?
No, Your Honor, I don't think that the officer is alleging that he didn't understand. I think he's actually alleging that the license plate was defaced, and I think factually it's not. So I don't think there's a way to say that the officer mistook the law. I think it's just the facts are just not what the officer claims they are.
What he says is that it looks like that the paint on the plate was peeling or defaced. And like I told you, I looked at the video and I didn't feel like I had a close enough view of that plate to address that particular factual finding. Obviously you disagree, and that's fair. But I wonder independently if there isn't a deferential analysis that we would apply to that finding if my colleagues agree with me and not you.
I would say not to the officer's factual finding. If your colleagues agree that it's not clear, then I think the trial court would have competent substantial evidence. If you don't agree that the license plate is as clear as I think it is, then the trial court would rely on the officer's testimony. So yes, I think then there would be deference. But if, for example, your colleagues disagree, then I think you could reverse that factual finding. And I would just request to reserve the rest of my time for rebuttal.
Okay. And Ms. Kohler, you may proceed. Got you on mute. You're on mute.
Yeah. May it please the court, my name is Pam Kohler. I represent the state of Florida in this appeal. She's challenging 3 separate rulings by the trial court. The first one that she raised in her brief had to do with the time to contact K-9. Basically, when you watch the stop, he goes up, tells the defendant why he stopped him, goes to the back, reads off the tag because he could not read the tag at the time he was trying to stop the vehicle, which is obvious. You can see him lift up his computer and then put it back down because there's no way for him to be able to read it. So he stops and then he's able to read it and read it off. Of course, the car is not registered to the driver, it's registered to his mother. So that doesn't give him any information about this defendant himself. So then he goes back after he gets the guy to agree to that he would consent to a search. He comes outside and then they have a little discussion about he's not going to agree. And then he says, that's when the defendant withdraws his consent. And then he gets his driver's license and some other information. He's kind of heading back and then he's waiting for dispatch to clear up. And immediately after he calls for the K-9, he then calls in the defendant's driver's license to dispatch. So he would have had to wait, to be honest, for dispatch to clear up if he first had called in for the driver's license number to dispatch and then done the K-9. Either way, he was going to have to wait for the dispatch to stop because he explained that while they're dispatching someone to a call, you cannot interrupt the call. And then he's heading, and when he does that, when he gets back to his car, he puts down, the driver's license and talks about it. So I would submit that that was not unreasonable, that it wasn't that he stopped it to conduct a canine sniff, and that he immediately continued with the traffic stop and the mission of the traffic stop, which was to write these citations. As far as the cafe, the event numbers, he explained that he always does this, he always includes this. The mission is obviously, and I'm sorry, as far as the time to contact canine, the defense also complains about that the other deputy could have done something. And this deputy, Jacino, explained, he said, he was there for my safety to watch the defendant. I was there to conduct the traffic stop. So that's why he's the one who's handling all of these tasks as part of the traffic stop. Secondly, as far as the cafe, the event numbers, he said he usually includes that on his report. He did not include that information on this report in this case. But again, this is part of the mission of of what we were there. It's not as if he was looking to see if the defendant had a trespass warning for the restaurant that they had stopped at to conduct this stop, or as you said, gone and look at Instagram. I mean, he's doing what he needs to do to fulfill his duty as an officer in writing these tickets.
Can we go back to the first point? Because I think that's, well, at least from my perspective, the more interesting one. Is there a viable construction of that video that suggests that he wasn't moving back to the car anymore, that he just stopped, wasn't doing anything to advance writing the ticket or effectuating the purpose of the stop, and he just stood there for, I don't know, 30 seconds, 40 seconds, a minute, and called canine? Talk to me, please, about the impact of that construction of the video in light of the case law that we discussed with appellant's counsel about that permissibility.
Sure. When you listen, when you watch it, the reason he stops, he's starting to walk back, and the reason he stops is because there's too much traffic on dispatch. He can't get through. So that's the reason why he stopped and waited for dispatch to clear up. And then once they cleared up, he started heading towards the car. But I would also
then it looks like once he waited for dispatch to clear, and I'm not arguing that, he started walking back to the car. He stopped, and before he got in the car, that's when he made the canine call.
And then he also took out the driver's license and put the driver's license up on his car, and he read it. He also dispatched that over the radio, like a few seconds after he finished with the canine. I'd say it's more like Van. I never can get that word. The case out of this court, Van Gisbeck, where basically they didn't have mobile computers, so that they had to do things over the radio. Everything was over the radio. In this case, he had to wait for dispatch to clear up. And so as soon as dispatch cleared up, I mean, you can see he's waiting for it. As soon as they do, he's on the radio doing the canine. And then after he gets the confirmation from canine, he goes and he puts the defendant's license up on the side of the car, and he reads the license off. And that's when he gets the information back that these negative and whatever, a valid negative, I think, is the dispatch.
So it seems like you're conceding that if the video shows that he didn't do anything for, say, a minute, other than call in canine, that it's an illegal stop?
No, I would say that he was waiting. He had the right to, I mean, he had to wait for dispatch in order to clear up, in order to make the call. So he could have, I mean, if dispatch had been clear, he would have been able to, as his way back, he would have been able to call in. Or, if he decided to run the DL, the driver's license first, I mean, it's either or. He was going to have to wait for dispatch.
Let me ask it in the form of a hypothetical. Assume a different stop where all things are equal, except that instead of waiting dispatch to clear, he just stopped. He wasn't advancing the purpose of the stop at all. Say, for example, because he was the only officer at the stop. And then for a minute, he just sat there and called in the canine. Is that an illegal stop?
Well, yeah, I mean, you have to show that it essentially, that I would submit that that it unintentionally or intentionally and unnecessarily prolongs the stop. And in most of these cases, it's where the officer stops doing anything and basically, gives up the fact that they're about to write a ticket and they start doing the canine sniff or whatever. Here it was just calling in for the canine.
Is my scenario indicative of that situation?
I mean, when it's only a minute, I understand it's not de minimis. Is it reasonable? Is it, unreasonable to stop there for a minute and wait to call and talk to dispatch in order to get the canine unit coming? Obviously, he can't wait until he's, at some point, it'll be too late to call canine. So if if canine's going to get there at all, he needs to call before a certain period of time.
He just needs to walk back to the car really slowly while he's
Well, yeah, I mean, it's, in the one case that they talked about that while he's waiting for the dispatch to run the tag or run the driver's license, that's when he called for canine. Perhaps he should have done that in this case. But again, when he went to do either run the DL or the canine, the dispatch was busy, so he was unable to get through. At some point, is it unnecessarily and intentionally prolonging the stop? That's, I think, what has to be determined. In this case, the trial court found the officer to be credible and that he was not intentionally or unnecessarily prolonging the stop by doing so. And basically, it wasn't the actual conducting the canine sniff that delayed the stop. By the time the canine showed up, of course, he was still working on the second ticket. So I don't know, is that conducting a canine sniff or, because that's what the judge found, was that this was not conducting a canine sniff and it did not, conducting the canine sniff did not extend the stop at all because he was still in the midst of drafting the ticket. I mean, he still had another minute or so that he was working on the ticket, but he had to print out the second ticket before he actually was able to get out after the canine had alerted on the defendant's car. So essentially it didn't prolong it as far as the fact that it took maybe an extra minute, most of which was because of dispatch being busy. So I would say that so long as the fact that he was still, there's still at least a minute before the canine, that the canine got there, that he was still working on the second ticket, that there was no unnecessary prolongment of this ticket or this stop. Also, I did actually review the video, and actually, when you watch the deputy, when he's finished, he's printing out the second ticket. He's holding up the first ticket to the second ticket, and when you look at it, you can see that it's actually the first ticket was for the light. You can see 316.605, not 316.221. So the one on the left is the one that's already been printed out. So it actually was the ticket for the light is the first ticket, no, I'm sorry, I've got it backwards. The first ticket was for the tag itself, the obstructed tag. I'm sorry, I'm totally messing this up. I apologize. It's at 27.25 in the video, the first video. And he holds it up and it's 316.221 for the tag. And he's the one that he's held in his right hand is 316.605 for the light. So he's already printed out and then finished with the first ticket, which had to do with the light. The one that they're alleging was basically issued just to unnecessarily prolong the stop. So actually it was, if you do watch that, it's when he's printing out the second ticket and he's comparing the two, you can actually see the statute number on the first ticket. As far as the probable cause for the first ticket, obviously it has to be objectively reasonable. And again, you have to show that there was some sort of, it was done to, intentionally and unnecessarily prolong the stop. The first tag was for the obscure tag, or first ticket was for the obscure tag in this case. And again, this is all part of the mission of this was to write the tickets. The case law, as far as the Morris case where the basically the court found that having the tag frame was not, as a matter of law, a traffic violation. That's not what we have here. I couldn't really tell from the videos whether or not that was a properly painted tag. Well, obviously, by the time you get to see the tag, you're very close up. He's got his headlights, plus you've got the floodlights from the restaurant there in the parking lot. You can't really tell if you can see it or can't see it within 100 feet from the tag or from the car, between the deputy and the car. And you can't even really see it if it's at 50 feet, which is when it violates the tag part of it. So again, I would submit that the trial court's finding was that essentially he believed the officer that he didn't do these things, that he had probable cause, and he didn't do this to unnecessarily and intentionally prolong the stop. He worked on it pretty much from the time that stopped. I mean, he was unable, he had to take time to read the tag after the car was stopped because he couldn't read it, which would bolster the officer's testimony that, because sometimes you can still read the tag from 50 feet, even if one of the lights is out, which is what it sounds like. The one of them was defective or out. As long as you have the one tag light and it works and you can still read it at 50 feet, you're fine. But the fact that he was unable to do so in this case would offer some support for the deputy's testimony that not only was that, but that because of the paint issues, the digits were difficult to distinguish from a distance. Do you have any other questions for me? I would ask that you affirm. Thank you.
Thank you. McHenry, you've got a little over 3 minutes.
I just want to begin with where Your Honor, Judge Traver had a question about the call to K-9, how long that took or dispatch. I just want to kind of clarify what the facts are. So the call to dispatch, I'm going from the number on the top right as indicated in the briefs, the wait for dispatch to clear happens from 2:19 to 2:30. So when the officer is actually standing still to make the call is, Your Honor's hypothetical, he's standing still for a minute from 2:30 to 3:33, just calling in the location of K-9. The appellee's response that there needs to be some sort of proof of intentionally delaying the stop, I think, is not what the case law suggests. The case law suggests that the officer needs to be addressing the infraction and it can last no longer than is necessary to effectuate that purpose. Is the officer being diligent? He doesn't have to be intentionally trying to delay the stop for this court to find that the stop was prolonged. He just has to have actually delayed it regardless for any period of time.
I appreciate your candor earlier. I think it was in response to one of Judge Wallace's questions about there not being any case law that was precisely on point to this scenario. I'm familiar, and I think the panel's familiar with the de minimis discussion going on. What would you say is your best case to apply the fact pattern that we have before us to that violation in terms of it not being de minimis? I know I got a little bit convoluted there at the end. Let me know if you didn't understand.
Yeah, I think the Campbell decision, which is actually, it's not binding on this court, but in Campbell, they go through every kind of past decision and they point out that there's usually two officers, and the Ninth Circuit's decision in Campbell goes through other decisions, and in every one of those examples, there's two officers. I think the Jones 4th District Court of Appeals decision is helpful because it focuses on the language that it's the detaining officer's job not to prolong the stop. I think Jones' situation and the way that the 4th District wrote that language suggests that the detaining officer is the one that can't prolong the stop. And that by having that minute call in this case of doing nothing to effectuate the purpose of the stop, it's impossible to say that the stop wasn't prolonged. And additionally, I think besides that call to K-9, when you stack in these unrelated inquiries and preparing for traffic court, I just think there's no way, the way the facts are in this case, which I think is what matters, I don't think this court has to say that an officer can never look for warnings. Just that the way that it was done in Mr. Ortiz's case, where the warnings were looked for and the officer admitted he wasn't using them for any purpose except to prepare for traffic court. It wasn't about the traffic ticket or stop, that it's impossible to say the stop wasn't prolonged for those 2.5 minutes it took him to go find warning numbers he didn't even put in the event ticket. And then just as a brief last remark, I think I think an officer should have to use whatever that best computer system is. So when we've got these duplicative checks, the officer should use only the one that provides him more information. In this case, that would be David.
Okay, counsel, thank you for your arguments. It was a very well argued case, and we are going to be, we're adjourned. Have a great day.
Thank you too.